Well, good morning and welcome to latest edition of our Life Sciences Legal Forum. Today, we're going to look at the impact of recent changes to UK public procurement law and what it might mean for suppliers as well as buyers operating in the life sciences sector space. So principally around the supply of medicines and vaccines and devices and technical services into the UK public sector. What we're not going to focus on today is the grant process, so your marketing authorizations and pricing and reimbursement, although we can cover those off in a subsequent session. So we're principally looking at the mechanics of actually supplying products and services into the UK public sector. So we're going to focus really around what is new in that space, but also to focus on where the opportunities are for you as private suppliers, what you need to be aware of, some of the tips of the trade. How do you prepare, the steps you need to take? And I'm delighted to be joined by two of my partners, Shaylee and Kevin, who actually I'm going to just ask for them both to introduce themselves, and then we'll kick off with the discussion. There will be plenty of time for Q&A as we go through. If you use the Q&A function just to feed your questions to, and I'll make sure that those questions get posed to Shaylee and Kevin. So without further ado, Shaylee, do you want to go first and just introduce yourself?
Yep. Hello, everyone. Good morning. So I'm Shaylee Howard, and I specialise in all things public procurement, advising authorities and suppliers alike to navigate the procurement regime through from procurement strategy all the way through to sort of contract award at the end. We act for all sorts of different types of authorities who are operating in the life sciences space, as well as sort of regulators and also acting for providers and suppliers as well. So we can see things from both ends.
Thank you, Shaylee. Kevin.
Hi, I'm Kevin Calder. So I'm a procurement and commercial partner and advising on a wide range of procurements, including both life sciences procurements, things such as vaccines, and technology procurements as well, like Shaylee acting for both public bodies and suppliers.
Thank you. Thank you both. Well, maybe I get things going. And before we go into sort of the nitty-gritty of the changes brought about by the new Procurement Act, maybe I can turn to Kevin first of all and just pose the question: why, as private companies, do we need to care about procurement law?
Thanks. Well, it's a good question, and you might say, well, isn't that a kind of public sector problem? And in one sense, you'd be right, because procurement obligations are placed on public bodies. So if you're in the private sector, hooray, you don't have to worry about that. But if you want to sell to the public sector, you'll probably be wanting to understand a bit about how buyers make their decisions, and perhaps how you can influence those decisions, or at least influence the process by which the public sector is going to arrive at its decision. And also, how can you maybe use the procurement law and the rules that affect the public body to gain market intelligence, potentially improve your prospects of driving sales, increase your market share, and so on. So whether you are a buyer and bound by the rules, or a supplier, it's well worth knowing about it if you're involved with the supply to the public sector.
Thank you, Kevin. We obviously premise a lot of this about changes to the UK public procurement regime. And maybe I turn to Shaylee and maybe just sort of talk through what has changed recently, and then maybe we'll sort of dive into some of the more detailed aspects.
Yeah, so sort of historically, procurement law was based on EU directives, and those were transposed into UK law by way of the Public Contracts Regulations 2015. But you sort of had the EU directives, you had the UK law, and then you had EU case law and UK case law and lots of guidance. And that's been the case up until now. Brexit provided the opportunity for the UK to sort of go its own way. And really, the UK used that as an opportunity to update procurement law and sort of forge its own path. Recognizing that there were still sort of international treaty obligations that we need to comply with. And I remember sort of the heady days of the first lockdown. There was a green paper all about procurement reform, and that has eventually made its way into the Procurement Act 2023, which was implemented earlier this year in February of this year. So we've now got my handy little copy of the Procurement Act 2023. We've also got some procurement regulations, procurement policy notes and guidance. So we've gone from that sort of EU regime with the sort of Bank of EU case law, etc., to what is now very much a UK-based system. There are some similarities between the two, but as we'll go through, there are some sort of quirks that mean that actually the UK is now doing things pretty differently from sort of EU counterparts.
Thank you. And obviously, one of the changes is around the transparency regime, as I understand it. And as a supplier into the public sector, how can I make most of that transparency regime, Shaylee? Maybe
Yeah.
talk through that.
Yeah, so at the heart of the reform, one of the key objectives was to really sort of pull UK procurement up by its bootstraps and really make it world class was sort of the aim and the objective. And to do that, Cabinet Office saw increased transparency as being the best way of implementing that aim. And the way that sort of manifests itself in the regime is we've got Find a Tender Service, which is the government-wide platform for all things to do with public procurement. And there are a whole host of notices that an authority will have to publish when they are planning a procurement, running a procurement, and then managing a public contract as well. So really, there's a whole sort of roadmap, I suppose, where the idea is that you're meant to be able to see a contract through from its sort of inception all the way through to sort of running of the process, to contract award and contract management. So it's a great way for suppliers to understand what opportunities are out there, what opportunities are coming up, but also to understand what competitors are doing as well. So which contracts have been awarded to competitors, how those are being managed. So there's really that sort of dual purpose of the Find a Tender service. And we have got some of our supplier clients who are really taking that quite seriously and sort of looking at market monitoring, so they can have a keen eye on the sorts of notices that are being published where they may have missed out on opportunities, where their competitors are potentially sort of winning more or more sort of kinds of work. So transparency really is at the heart of this, and I think there's an opportunity there for suppliers to not only see what is coming up, but also recognise which bits they're not potentially seeing and how that is being managed and procured.
And what's the supplier information service on the Find a Tender service?
Yeah.
Maybe just talk around the sort of information that may be available, Shaylee.
Yes, so you've got all those notices, like I say, in terms of a lot of information to suppliers into the market about the nature of the contracts being procured. Another element of Find a Tender service is something called the Supplier Information Service. And as a supplier to the government, you are expected to register on the Supplier Information Service. You're given sort of a share code, and that is a code that is specific to the bidding entity. And the idea is that you publish information as a supplier about sort of basic company information, likely to be your sort of accounts and your company's house registration details, as well as information about potential subcontractors and consortium members. And the idea is that you sort of provide that information once, and then all the authorities have access to that same information. So it's meant to sort of streamline that part of the procurement process, so that as a supplier, you are only providing that information the once, and every authority that you're bidding to will have access to that same information. So if you're a
Thank you.
supplier, sort of well worth sort of familiarising yourself with that
Yeah.
if you haven't done so already.
And obviously that act hasn't been in that long. And you mentioned actually the aim is to coordinate. How is it happening how's it working in practice then?
So there are, in terms of coordination of supplier information, I think suppliers are, there are lots of suppliers who have actually registered on the portal and sort of streamline that bit. I think there's still a way to go. One of the things that we are seeing is, and I'm sure Kevin will come on to talk about this, is that there are some parts of the Act which haven't been implemented yet around contract performance and the contract management stage. So that bit is still sort of TBC, but yes, I think that there was a slight reticence to sort of launch procurements under the Act because everyone was rather nervous about the big scary world of all these notices, etc. But I think that's largely settled down now.
And maybe we can talk about one of the other changes, which is around preliminary market engagement. Maybe I'll turn to Kevin to talk about what that is. But then I suppose the follow-on question is how can a supplier get the most out of that PME process?
Yeah, sure. So, yeah, preliminary market engagement is the idea of buyers and suppliers have speaking to each other before a formal procurement process starts, and buyers used to be quite nervous about that. So there was a bit of a perception that if a public body started talking to suppliers before it had kicked off a procurement, it would somehow be unfair or represent unequal treatment. But actually, the mood's very much changed on that. It's now very clear that it's best practice to do that, and it's specifically not only recommended but it's expressly permitted in the new legislation, the Procurement Act that Shaylee mentioned. And it's actually seen as even more important now because one of the things that in theory the new Procurement Act gives public bodies is a lot more flexibility about how they buy things, but with that flexibility comes a bit more need to speak to the market, speak to suppliers, and say, well, we're going to do this. Is that going to work for you? But clearly, it's really important for suppliers because as a supplier, it's your opportunity to influence the buyer or influence the process before the formal process is kicked off. Because the way procurement works is it's much more difficult to change things once a formal procedure is in train. So if you really want to influence the process, you ideally want to speak to the buyer before they've kicked off the formal procurements. So preliminary market engagement allows you to have that discussion, and that discussion might be about the scope, what the requirements, what the buyer actually wants to buy. It might be about the process, how they're going to run the process. Are they going to have a negotiation phase? What are their requirements, the minimum requirements for bidders? It might be about the contract terms. Certainly, there have been a number of occasions where public bodies have pushed out contract terms and suppliers have gone, not sure that works for this particular product or service. So again, it's an opportunity for the buyers to test, is this going to work? If we ask for this, will you bid? Will you be interested? And it's an opportunity for suppliers to say, well, sorry, that's not market, or it would be much better if you did it this way. We'd be able to deliver more value to you. And the key change under the Procurement Act is Shaylee's mentioned transparency. One of the notices that's new is called a preliminary market engagement notice. And that is effectively mandatory for buyers to publish one of these notices, or if they don't, to give a very good reason why they haven't. So that they're expected to publish one of these notices if they are going to carry out preliminary market engagement. And it's worth bearing in mind there is no obligation on a buyer to talk to everybody. So if you're a supplier and you want to be involved in that discussion, you need to watch out for these preliminary market engagement notices. You need to register and you need to get involved in that process and make sure really that your voice is heard, find out what the buyer is doing, answer their questions, try and respond and get involved in those discussions so that you're really influencing how the procurement goes to your advantage. And worth thinking also about what would good look like for you if you're a supplier. What sort of things do you want to be in the requirement and contract, and then trying to feed that into the process with the hope of sort of steering the ship of the procurement in the right direction, if that makes sense.
Yeah, because presumably, Kevin, you're able to influence particular conditions around the tender going forward. So technical requirements for a product. So, for example, I don't know, software as a medical device, for example, you're able to almost sort of influence in terms of usability within the market and influence the buyer around that. So, is your view? Yeah, you should look to seek to sort of actively engage in that kind of process.
Absolutely. So in a lot of cases, particularly for new life sciences technologies, but buyers may not know what's out there or have a good feel for how new products work, and sometimes what they're asking for isn't quite aligned to. So there may be a completely different solution to their problem, which would work brilliantly, but they're kind of constraining themselves by asking for it in a certain sort of way. So again, if you're involved in that discussion, you can say, well, actually, we've got a totally new product which doesn't meet these requirements, but does actually deliver the same therapeutic benefit. If you change your requirements a bit, we can bid with this, and we think that would solve your problem. So those sort of discussions can be really valuable to the buyer as well as suppliers. So yeah, definitely worth getting involved if you can.
Great.
I think we've also experienced, haven't we, that sometimes suppliers are reluctant, aren't they, to have those conversations because they're worried about seeing unduly influencing the authorities' decisions. But actually, I think the things that Kevin has described really demonstrate that it's something that is actively encouraged, and really authorities ought to be publishing notices to advertise those sorts of opportunities.
Fantastic. And so I suppose another, as I've picked up as a sort of non-procurement lawyer, that actually there are more limitations going forward around. I think we'll come back to contract changes further down the route, but particularly around direct awards. And I'd like to sort of explore with you, Shaylee, sort of those circumstances in which you can avoid having to tender. So I suppose first question is actually, is it easier to get a direct award, i.e., not under a framework under the new Act?
I mean, we get asked this question all the time, both from our sort of our provider clients and our authority clients who may not have the time, etc., or sort of budgetary constraints, etc., around running a procurement. I guess there are two sort of types of direct awards, as you say, James. There's direct award as if it's sort of permitted under the Act, and there are sort of grounds under the Act which allow for direct awards in certain circumstances, and then separately you have direct awards under frameworks, which I'll talk about in a minute. So looking at sort of direct awards under the Act, there is a list of direct awards. There was under the old regime as well. It has slightly changed, but otherwise looks pretty similar. There is sort of one additional ground around repetition of an already competitively procured contract, but the authority has to make sure that they have paved the way for that during that competition. It's not necessarily a sort of repeat order sort of process. So there are conditions around that. I think it probably is a little bit harder in the sense, going back to that whole sort of objective of transparency. So where a direct award is being made, in most cases, there is an obligation on the authority to publish a transparency notice ahead of making that award and have a standstill period. So that really sort of increases the profile of that direct award in a way that sort of wasn't the case under the previous regime, which is likely to make authorities a little bit more cautious when they are proceeding to directly award a contract.
Right. Okay. Do you want to talk about direct award under a framework as well, Shalia? So
Yes.
is that easier to do under the new Act?
Again, sort of probably not. I mean, under a framework agreement, so this is where a provider has a place on a framework agreement, and then authorities can effectively call off as and when they have a requirement. So you may be one of several suppliers on a framework. And there are generally sort of two mechanisms to allow an authority to call off from that arrangement. There's a sort of mini competition, which is very much a sort of tender process, or a direct award. And it's the same position under the Act that the customer's can only make a direct award where the requirements are very clear. So all the terms and conditions are set out, and there is some sort of objective mechanism for deciding which of the suppliers the direct award goes to. So that's all the same. If the call-off contract is for over £5 million, then the authority has to publish something called a contract details notice. And that is a notice sort of setting out the details of the contract that's been awarded pursuant to that framework agreement, as well as publishing the terms and conditions as well. So again, that sort of raises that transparency in a way that we didn't have under the previous regime, which might make customers a little bit more nervous, reluctant to sort of depart from the terms and conditions that were set out under the framework. So yes, I think that increased transparency means that where there is no competition, you may well find that authorities are a little bit more nervous about making direct awards.
Thank you. And you mentioned frameworks, and I'd be keen to sort of talk about now what is new in relation to frameworks, the whole concept of open frameworks. So maybe a question for Kevin. So are the new open frameworks both worth it from a supplier perspective? Kevin, you're able to sort of talk to that. What are they, and how is it working through in practice?
Yeah, no, and it's worth saying that, I mean, in terms of for those that aren't familiar with frameworks, certainly if you were to look at NHS spend, probably most NHS spend is under frameworks. I mean, these are massive in the sort of UK health sector, and those who operate in this market will know about frameworks run by the Crown Commercial Service, run by NHS Supply Chain, run by NHS England. But it is, and the reason for that is that the concept of a framework is that you sort of do the procurement, the big procurement once, and then, as Shaylee was just discussing, you then have this sort of call off once you've decided who's going to be on the framework. So the open framework, to answer your question, is trying to change is trying to make it even easier in a sense. So when I say you do the big procurement once, I mean you set up the framework once. Well, the open framework is trying to say, wouldn't it be great if once we've set the framework up, we could kind of just set it up again and again and again without having to go through the same tendering process, which is quite painful for the buyers, but it's really painful for suppliers. I mean, getting on a framework is a major thing. In some spaces, it's absolutely critical for suppliers to the health sector to be on certain frameworks, because so much NHS spend goes through those frameworks. If you're not on the framework, you're basically out of the market for a period. So there's a lot of effort to get on these frameworks. So open frameworks, the concept is at the moment, under the previous rules, you could have a framework for up to 4 years. An open framework can last up to 8 by being regularly renewed during that period. And depending on how it's set up, the way the renewal potentially can work is if you're on the first framework, you get an automatic place on the second, or the buyer can just relook at your submission first time around and reuse it. It does depend on how the framework's set up, but assuming it's an unlimited number of suppliers on the framework, they can do it that way. If it's a limited number of suppliers on the framework, they will still need to review submissions, but again, they can do that in a slightly more streamlined way for the relets. So the idea is to make it a lot easier for buyers to set up sort of frameworks over a longer period. So that should be good for everybody, in the sense it's less work if you're a supplier, less work if you're a buyer, and hopefully a bit less stress about the sort of dreaded 4-year framework renewals.
Okay. So you talked about some of the advantages. Are there any disadvantages from a supplier perspective?
Well, I mean, the nervousness, I guess, will be that for an open framework to work, it's got to be relet on essentially the same terms as the first time around. So that means that once a buyer has made decisions about what it wants to buy and how the framework is going to operate, those decisions are likely to be carried forward for a longer period. So
Yeah.
if, as a supplier, you don't like the way the framework's structured, either because you don't like the way the products are categorized, and feel your product's been excluded, or you don't like the way the criteria work to select, as Shelley mentioned, sort of mini competitions, you don't like the way it's structured, you might be stuck with that for a longer period. Whereas under the old regime, every framework could be completely different. So it does potentially mean that if you that a framework which doesn't quite work for you could be relet on similar terms repeatedly. But again, it doesn't have to be the case. There's nothing to stop a buyer changing its mind and moving to a totally different non-open framework. But if it does want to relet an open framework, it will be on essentially the same terms each time.
Yeah. And I suppose one of the sort of, related, you're bound into a long period of time in terms of contracts being awarded on a particular framework, the flexibility to make contract variations over time. This is a sort of common issue that we are asked by our private sector clients. And maybe a question for Shady now. So does the new regime make it more difficult to make contract variations after the contract's been signed?
Yeah, so procurement law, I'm afraid, has something to say even once you've awarded the contract as well, because it's a public contract, and there are sort of rules around how that contract is managed, but also if that contract is changed. That was the case under the previous regime and continues. It probably is a little bit harder, again, going back to that sort of objective of increased transparency. As before, there are sort of set scenarios in which a variation can be lawfully made to a public contract, and the way the law works is that if you're not within one of those scenarios, then you are sort of deemed to have an authority is deemed to have let a new contract which ought to have been subject to its own competition, and that can be sort of challenged. And so thinking about those sort of what those grounds are, there are sort of grounds where you can set out what potential extensions or variations might look like, but you've got to do that up front. So the authority has to set out quite clearly what those potential variations might look like. That's the sort of thing that could almost be part of pre-market engagement as well, as Kevin said, in terms of what, if we all had crystal balls, sort of where might we see this contract going, and what do we want to allow for by way of an optional extension or addition. So that sort of added flexibility is there, but you really got to think about it right at the beginning. Apart from that, I think the permitted grounds are pretty much the same. There is a reference to a new ground where there is a known risk, but again, that's got to be something that has been thought about right at the beginning when you're procuring it. So there is that sort of crystal ball is needed there. I suppose the key difference under the Act is that, again, looking at those notices, there's a contract change notice that is required, and that has to be published before making any changes. So again, really raising the transparency of variations that under the old regime competitors may well not have known about. So and we do have experience of working with a supplier who was very much monitoring the notices that were being published, noticed that there was a very, very lengthy extension, of massive value being awarded on a contract that they had originally missed out on. And we got involved to sort of just gently inquire as to the legal basis of that extension. And eventually the authority sort of accepted that that wasn't a permitted variation, and has sort of gone back to square one, which has given our client the opportunity to bid for that. So there's an example of where suppliers are actively looking at the market and in the context of a contract change.
And this is why presumably it's important that you are looking at the find a tender service. So a lot of the
Absolutely.
misinformation is there. So known risks, presumably those are they is that information you're able to pick up on the FTS?
Yeah, so the idea is that if you are relying on that ground of a known risk, then that's got to be laid out in the contract change notice. So the contract change notice really ought to have a bit of detail about what that known risk was, and there ought to be a link between how that was articulated in the tender notice versus what you've got now. So I think that's the idea. And if you haven't got that detail, then yes, that is susceptible to legal challenge.
Yeah, thank you. I suppose the other thing, I think you mentioned it towards the beginning of the discussion, just around contract performance. And Kevin, I think probably it'd be useful to just to understand what this concept is. It's around reporting poor contract performance, as I understand it, and why is that important to a supplier base?
Yeah, so this I think is one of the most potentially one of the most interesting areas of change, because it could have a very dramatic impact on your business if you're a supplier to the UK public sector. It's worth saying that aspects of this are not yet in force, but they are expected to be soon. And we think the reason they're not in force is because this only applies to contracts let under the new Procurement Act regime, and they're only just starting to come through. But the background to this is that government's been keen for a while to try to enable public bodies to take into account previous poor performance when you're choosing your supplier. So essentially the issue they've been grappling with is that there have been some suppliers who bid low and then poorly performed the contract, and then they've repeated that at the end. So even though the public bodies, not very happy with the performance, they've had to effectively reappoint someone because it's been a really low bid. So the government's keen to try and prevent that, and so the new regime's got several things which look at that. One is that there's this concept of KPIs, key performance indicators. So there's an expectation that if it's appropriate to do so, a contract will have these key performance indicators, and then they will be published. The performance of the supplier against those will be published at least annually. So again, that's already interesting in the sense that you will be able to see and access information about how your competitors are performing under their contracts and have a look at these KPIs. But also, the public body is under a legal obligation to publish a contract performance notice if there is a material breach of contract or a failure to perform the contract to the satisfaction of the public body. And by the way, you might be thinking, failure to perform to the satisfaction of the public body, that sounds quite broad. Yes, you'd be right. It is very broad. And there's a legal obligation to publish this notice. And again, the notice is public and will contain details of the breach or why the public body isn't satisfied. So it's bad enough that is public, because I mean, if you're a supplier to the public sector, you really do not want a public notice saying supplier X has been rubbish because. But it's worse than that, because once one of those notices has been published, you become what's called an excludable supplier, and you become that purely because one of these notices has been published. If you're an excludable supplier, it has two really quite significant consequences. The first is there is an automatic implied right for public bodies to terminate any contract with that supplier that's been awarded under the new Procurement Act. So yeah, that's already quite serious if you've got a lot of public sector contracts. Again, it's a right to terminate. It's not an automatic termination, but that's still pretty serious. The second is, as an excludable supplier, you can potentially be excluded from all future procurements under the Procurement Act for up to five years if the public body running the procurement thinks that the issue is relevant to them. So if the UK public sector market is important to you, this effectively means that one bad contract where you've got a real problem can cause a serious issue across the whole of your UK supplier base and reputational issues. And you might say, is it really as bad as it sounds? Well, there are various stages of this where suppliers can make representations to the public body, so they can explain why they don't think there should be a notice, why they don't think it's so bad. Suppliers can do something called self-cleaning, which is when they can say, actually, we've taken this really seriously, we've fixed it, this will never happen again, etc., etc. But this regime does exist and exists for a reason, and there is an expectation that it will be used. I mean, there's another regime that runs alongside it, which you may have come across, called the debarment regime, where a minister can decide that a supplier is excluded or excludable. And that almost a couple of days after the Act came in, the government said, well, we are going to look at using that in relation to some of the Grenfell suppliers. They haven't appeared on the list yet, but they may do. So the government's quite serious about making this work. So I guess a number of consequences there. If you're a supplier, you want to make absolutely certain that you can meet KPIs and contractual obligations. Don't commit to something you can't deliver on, delivery times, implementation, etc., etc. And also potentially a great source of information about your competitors. You will no doubt be watching for the publication of KPI performance, etc., for other competitors, and look at what's going on with that. But and the other big action is if a contract is going wrong, you need to jump on it, take steps to deal with it, and try and do something before it escalates into the public body feeling they have to publish one of these notices. So quite a lot to unpack there, but that could over time be one of the sort of really significant areas in the Act, we think.
Sounds significant. You mentioned it's not in yet, Kevin. Any sense in terms of when it's going to come in?
Shaylee and I were discussing earlier, because we haven't had formal. We kind of assume soon, don't we, Shaylee? Because as I say, the reason it didn't need to be in straight away was because obviously on day one of the new Act, you don't have any contracts awarded under it. But now we are starting to see procurements concluding. So you would have thought pretty soon, but I don't think we've had a heads up, Shaylee, have we yet?
No, we haven't. I think that, and as you say, originally, I think there was something to do with the find a tender service portal sort of not being effectively ready to publish the contract performance notices. But as Kevin says, we are now seeing some fairly sort of significant contracts being awarded under the new regime, but very much a watch this space. And I think there is a distinction between the obligation to sort of set those KPIs as Kevin described, and then there's a separate obligation around publication of the contract performance notice. So you may well find as a supplier that you are being asked to sort of have those set KPIs, but the obligation to publish hasn't yet come into force.
Yeah. Okay. The questions are starting to come in, and please do send those through on Q&A. And I want to allow sufficient time for Shaylee and Kevin to look at those. But before I do that, just one last question, and then I've got a question right at the very end after we've done some Q&A. Just around, if you're a supplier and you think that something has been done unlawfully by a potential customer, such as a variation or direct award, what can we do short of a formal High Court challenge? Obviously, we've got JR at the end of the line, but just in terms of before you get to that step. So, any thoughts, Shaylee?
Yeah. So yes, you have judicial review, as you say, James, and there's also a sort of full High Court challenge regime that's specific to procurement claims under the Act as well. So those are still available, but we often have our clients not necessarily wanting to hit that big red litigation button. You can sort of effectively, and you are encouraged actually to engage in pre-action sort of correspondence. So complaining sort of directly to the customer where you think that something hasn't been particularly transparent, or the wrong decision has been reached, and that may well be as part of a sort of initial legal letter, even if it's drafted by a lawyer on sort of your own letterhead, because that can sometimes sort of take the sting out of a potential complaint, but still sort of assert your rights under the Act. And we've found that can be quite a successful way of, as I say, sort of asserting your rights under the Act, pointing out where things might not have sort of been completely compliant with the rules, which may well enable the authority to sort of either change direction or abandon the procurement decision and maybe go back a step, etc. So that tends to be the way in which sort of suppliers do challenge and sort of complain. There's also something called the Public Procurement Review Service, which is part of the Cabinet Office and part of the wider procurement review unit, and the Public Procurement Review Service has been set up to provide suppliers with an alternative route of challenge. It's not time sensitive though, so I suppose it may well be useful to complain about something after the event, but might not necessarily get you where you want to be in terms of forcing the authority to sort of change its decision. They are sort of, in terms of their terms of reference, they are looking at sort of things like more thematic sort of issues, as well as sort of individual issues. So you've got this Public Procurement Review Service, you've got the sort of initial pre-action sort of legal correspondence. Those are probably the two ways outside of a formal challenge.
And if you're forced to then formally challenge, so thinking around that, practical steps you then need to take, Shaylee, has the new Act had an impact?
Yeah, so the rules are sort of effectively as they are, and sort of what's specific to a public procurement challenge is that where a claim form is issued before a contract is awarded, that automatically suspends the authority from awarding the contract, and then the authority has to apply to the court to lift that suspension. So that still exists. The things that have slightly changed is that there's now something called a contract award notice that starts the standstill period. So that's the period before, once the contract award decision has been announced, you've got to wait a certain amount of time. So it's 8 days under the Act. And then you can award the contract and sign the contract after that 8-day standstill period. Under the Act, you can only issue a claim within that standstill period. So under the previous rules, it was at any time before the contract was awarded, whereas under the Act, it's very much limited to that 8-day period, which is an exceedingly short time to sort of get your head around the fact that you've, as the supplier, that you've lost. You may well want to get some legal advice and then get that sort of claim form in. It's usual practice that suppliers will ask the customer to sort of extend that standstill period because of that sort of fairly draconian sort of remedy of suspending the whole contract award. In terms of sort of practical steps, it may well be worth sort of investing in some time creating a sort of challenge protocol. And that's something that some of our supplier clients have been doing, where they've got some fairly significant contracts that are up for reprocurement. They will spend some time thinking about what information is needed, what sort of correspondence might be required, so that they can hit the ground running within that very limited 8-day standstill period.
Great. Thank you very much. I wanted now to move to Q&A because there are questions coming in. And then probably I've got a last question, really, my usual question on these forums around take home points for the audience. Just one point of clarification, because it has come in on the questions, is are we looking to share a recording? Yes, we will in relation to this session. So the first question, which I'm going to direct to Shaylee. So this is around open frameworks. So if a supplier wasn't originally successful, Does this mean that they are effectively excluded from the market for the full 8 years, or could there be an opportunity to gain access at some point within the eight year period?
Mm.
Shady, are you able to take
It's a,
that?
yeah, it's a good question, and it's one that I think suppliers are sort of slightly worried about. I suppose the answer is it likely depends on the rules of the framework agreement, but the idea is that where you've got the 8 years, there are meant to be breaks within that where effectively competition is reopened. So where there is that sort of break, that would be the opportunity for that supplier who may well not have got on the first time to effectively try again. Um, it could be potentially that you weren't successful for whatever, whether that's a sort of pricing reason, etc. So there would be there would be that opportunity, but not necessarily a guarantee. I think the key is to look at the rules around how the open framework is going to operate, because as Kevin said earlier, there may well be rules around the minimum or maximum number on that framework agreement, the extent to which existing suppliers who might have made it on the first time, whether they need to reapply or whether they sort of effectively continue to stay there. That will make a difference to sort of how many spots are available at those sort of intermediate junctures when the framework is reopened.
Thank you. Thank you, Shaylee. And a question just around smaller suppliers, SMEs as well, has come in. And I'll address this one to Kevin, because I think the context we've been talking about are, yeah, larger scale procurements, but I'd be interested to sort of think around how do SMEs engage here and get involved, Kevin? Any thoughts?
Yeah, I'm sure. So, I mean, it's worth saying that, it is easy to get caught up in thinking we're only talking about massive procurements, but obviously, NHS bodies in particular have a huge number of lower value purchases, and a lot of the time these purchases are what's called under threshold for procurement purposes, which means they don't go through some of the formal steps we've been talking about. So there absolutely are opportunities for SMEs, but even in terms of the formal larger procurements we've been discussing, there are specific obligations now built into the new Procurement Act, which say that public bodies should aim to make procurements more accessible to SMEs and focus on removing barriers to entry for SMEs. So if you are a small supplier and you feel that a procurement is structured in an unnecessarily unfair way, which prevents you from bidding, then it is worth raising that with the public body, because they have an obligation to try and make sure that that isn't the case. And there are some other specific points. So public bodies also have an obligation to consider splitting up larger contracts into what's called lots. So instead of lumping things together, can you separate things out into smaller chunks, which again might enable smaller suppliers to bid for those. Another thing is, of course, as a smaller supplier, you don't necessarily have to be the prime supplier to the customer. You can be act as a sort of subcontractor or potentially a member of a consortium. And again, the Procurement Act tries to help with that, because there is an obligation on public bodies to publish something called pipeline notices, which set out in advance what a public body is planning to buy over the course of a year. But the advantage of that, if you're a smaller supplier, is that then potentially gives you an opportunity to get in touch with other suppliers in your market that you think might be going to bid for that, and say, well, I'm interested in partnering with you as part of that opportunity, and it potentially gives you more time to form those consortia. And there are various other things within the Procurement Act that are trying to help smaller suppliers. So things like prompt payment obligations on public bodies. There have been challenges in the past of getting prompt payment out of the NHS. That should be a thing of the past now. Addressing issues like need for insurance to be in place ahead of winning a contract. There's various other steps the government is taking to try and make it better for smaller suppliers. So the Procurement Act should be a good thing, and should churn out more opportunities.
And you mentioned consortiums, Kevin, subcontracting, etc. Any additional thoughts around that in terms of new act, either you or Shady? That's the third. That's the additional question we've got here in the Q&A. So any thoughts around, yeah, consortium bidding?
Well, I
Additional.
suppose Well, I suppose just following up on the bits I've talked about earlier, Shelley may have other thoughts, but in terms of we mentioned contract performance. So obviously there are very serious impacts, as we discussed, if you badly perform a contract. But of course, that applies not only to the prime supplier, but also to any subcontractors or consortium members. So if the contract is performed badly as far as the customer is concerned, that potentially has an impact for all the suppliers involved in that. So I suppose the take home there is pick your subcontractors carefully and make sure you take steps to flow down the relevant responsibilities to those subcontractors so that they're going to help you deliver on the KPIs and meet your obligations is one important point to bear in mind. But I think, Shelley, do you want to talk about the other points on?
Yeah. Yeah, thinking about the sort of the beginning of the process, and sort of the idea again, thinking about pre-market engagement, is that actually that can be used to help generate that supply chain to allow those smaller suppliers to get involved and for those consortia to be sort of developed. At the beginning, thinking about what I said at the beginning about the supplier information system, it may well be that if you've got a supply chain and if either the subcontractor consortium member is delivering a fairly significant part of the contract, then they will also need to make sure they have their information uploaded onto the supplier information system, because the authority may well want to run through checks in terms of whether any of the exclusion grounds apply to them, whether they're financially robust, etc. So all of those checks, depending on the sort of portion of the contract that's going to be delivered by either a subcontractor or a consortium member, likely to need that information as well. So well worth checking the instructions of the procurement at that stage. And then usually, particularly if you've got a more lengthy procurement or a multi-stage procurement process, if there are going to be changes to either the supply chain or the consortium members, there will be an ongoing obligation to keep that information up to date. So the authority has an idea of who in totality it's going to be contracting with. So worth keeping an eye on what that supply chain looks like, even if you don't have it particularly established at the beginning. If there are changes to it, there will be an obligation to keep the authority informed, who will then in turn have to sort of continue to sort of do those checks to make sure that they meet all of their minimum requirements.
Great, thank you. We've covered an awful lot of ground today, but I'm keen that we try and sort of condense it into final question 5 take-home messages for the audience today. And I'm conscious there are 2 of you, and I'm giving you an odd number, but let's go with 5. Who's gonna start?
Shelley, do you want to kick off?
Shall I go first? Okay, I think I'll end where I started in terms of trying to get the most out of that transparency regime. So there are a whole host of notices there in terms of the pipeline of what's coming up for an authority, through to sort of individual planned procurement of specific contracts, pre-market engagement, then you have the tender notice, etc., and so it goes. So there's an awful lot of intel there. So thinking about how you might make the most of that. As I said earlier, some of our clients are setting up sort of a market monitoring function to really inform their business development strategy and inform conversations with their customers and their targets. So that would probably be sort of takeaway number 1 for me.
Shall I go for? I mean, one thing. Well, it leads on from sort of the discussion about SMEs. Is obviously this is all quite new, and it's new for suppliers, but it's also new for buyers. So I think one takeaway is sort of don't be afraid of sort of pointing out to buyers if they seem to be doing things that aren't in accordance with the new rules. Public bodies want to comply with their obligations and the latest guidance. So, if there's something that doesn't work for you because it appears to be in breach of the rules, then it is worth raising it either in pre-market engagement, if you can be involved in that, or in clarifications in the procurement. And it's a journey that everyone's going on together.
Great, thank you, Shelley.
Yeah, I think picking up on some of the things that Kevin's mentioned around performance reporting, I think that is that is a sort of a fairly significant change. So taking some time to sort of think that through in terms of processes around how contract performance on current public contracts is being dealt with, to make sure that that's clear and there is oversight of what that looks like and what those conversations look like, so that you don't later on down the line have an issue where that becomes a performance issue that sort of renders you excludable in the way that Kevin has described. So paying a bit of attention to what the contract performance monitoring regime looks like on current public contracts is probably a good idea.
Great. Kevin?
Yeah, I was going to say something very similar, I suppose, which is I think if I was a supplier, I'd be wanting to pay very close attention, and perhaps more than I've previously done, to what the KPIs are. So, and do I need to negotiate those, or in extreme circumstances, should I not bid? So, previously you may have thought, well, I'll win this contract and I'll deal with it later. But most suppliers listening to this will not want a public notice saying that they're failing to achieve KPIs. So do check you can actually deliver what you promised, I suppose.
Great. Final one, Shaylee.
I'll take the final one. So I think there is a lot of I think sometimes people think that public procurement is a bit of a pain because there are lots of sort of hoops to jump through, and I think that's probably right, and continues to be the case under the Act. But I think there is an opportunity there for suppliers to try and streamline that process by thinking about those initial stages of the procurement and having sort of not necessarily stock answers, but a strategy around that initial stage of the procurement to demonstrate things like your experience. Spending some time thinking about that and streamlining that, I think, can pay dividends, because it allows you to get to the next stage of the process where you can talk about sort of what proposals you do have. But in order to get to that stage, you've really got to demonstrate that you've got the experience. So actually spending some time thinking about good case studies, etc., and how they demonstrate your experience is probably worth doing.
Thank you. Excellent discussion, very wide ranging. I think we've had lots of questions in which we've dealt with. Can I just thank the speakers today, Shaylee and Kevin? It's been an excellent discussion. We hope to see you at our next legal forum. Details will be confirmed ASAP in the new year. Thank you very much indeed. Thank you.
Thanks all.